last time we have discussed about the Securities and Exchange Commission Act. We have discussed. And there is another act, that is Foreign Exchange Act. Actually, there are two tables given here. Now, actually, this enactment is introduced in order to regulate the foreign exchange. And there are two types of investment recognized. One is recognized as inward investment and outward investment. Inward investment means foreigners invest in shares in the company, right? Incorporated in Sri Lanka. Foreigners invest money in shares of the companies incorporated in Sri Lanka. That is known as inward investment. That is inflow. In Sri Lanka, then, there are two types of transactions: inward investment and outward investment. But outward means Sri Lankan residents invest in shares of the foreign company, right? So inward and outward, inflow and outflow. Foreign exchange may be inflow or outflow. So in order to regulate that inward and outward investments, there are some restrictions introduced by actually there is a gazette notification under this. This is the Act, Foreign Exchange Act. Under this Act, the gazette notification is published. According to the gazette notification, we can identify the restrictions regarding inward investment and outward investment. And can I give you? You know, make a share inward investment again. කියන්නේ ලංකාවට එන ආයෝජන outward කියන්නේ ලංකාවේ එළියට යනවා. හරි. එතකොට inward investment එකේදී උනා restrictions හඳුන්වා දෙන්න මම හිතන්නේ මම හරියට හිතන්නේ අර තියෙනවානේ අපේ local industry එක ඒක protect කරන්නත් එපා. ඒ කියන්නේ ඔක්කොම පිටරටයි අපි ෆන්ඩ් කරොත් ගන්නේ සමාන තියෙන ශේෂ්ඨ නැති ගන්න පුළුවන්. ඒ ලංකාවේ තියෙන ව්‍යාපාර ඒ නිසා තමයි පොඩි restrictions වගේ දාලා තියෙන්නේ. හරි බලන්න මේ table එකේ ඉතර කියන්නේ table එකේ we can identify there are three columns, right? Under first column, actually foreigners cannot invest money in company which are carrying on business these industries, right? Which are carrying on business for pawn broking, retail trade, right? And coastal fishing. There are three industries identified. Therefore, they cannot invest. So, 100% restriction regarding these three industries, right? Owning and that the retail trade, right? And actually the capital is less than 5 million US dollars. If the capital is less than 5 million US dollars in a company which is carrying on business for retail trade, foreigners cannot invest. Foreigners cannot invest. It indicates actually if the capital is more than 5 million, they can invest, right? Even though it is retail trade, the capital is more than 5 million US dollars. You know, all are given in US dollars, right? More than 5 million US dollars, then they can invest. If it is less than 5 million, they cannot invest in such industry. Coastal fishing. වසුන් හා සම්බන්ධ තියෙන ඊළඟ තමයි ඔය. ඊළඟ ආයෝජනය කරන්නත් බෑ. Right? 100% restriction. Then according to the second column, right? Foreigners can invest only up to 40% of the stated capital. Right? They cannot exceed that amount. Right? In businesses for these Right? So businesses recognize yield. Right? Production of goods where Sri Lanka's exports are subject to internationally determined quota restrictions. Growing and primary processing of tea, rubber, coconut, cocoa, rice, sugar, and spices. So, the restriction is only up to 40% of the stated rate. They can invest, right? But first one, on the first column, they cannot invest. 100% restriction. Here it opens up to 40%. Right? Foreigners can invest up to 40% of the stated capital of the company. And the third column it says, right, uh, they can invest only up to the percentage which is approved by the government. The percentage is not yet determined. Right? So only thing is under these industries they can invest only up to the percentage which is approved by the government. Right? First we have to get the approval from the government. Then government can give the percentage, right? Then they can invest. And here it is specifically mentioned only up to 40%, but here it is mentioned as only up to the percentage approved by the government. Only up to the percentage approved by the government. ඒක හැබීටම දීලා නැහැ percentage එක. ඒක ඕන වෙලාවක වෙනස් කරන්න පුළුවන්. පොඩ්ඩක් නිකන් බැලුවාම ඒක ඉන්ඩස්ට්‍රි එක ඒකත් ඇවිල්ලා කියලා ලංකාව කණින් ආයෝජකයෝ නැති ශේෂ්ත්‍රයක් ඒ තියෙන්නේ. ඒ නිසා ඒකට ඒක සමානලට 100% උනත් ඉන්වෙස්ට් කරන්න පුළුවන්. ඒ අවස්ථාව තියෙන්න තමයි ඔය ගැසට් කරලා තියෙන්නේ. බලන්න මේ පළවෙනි එක ගත්තාම තේරෙනවා. air transportation. ඒ වගේ එකක් ගත්තාම තමයි ලංකාවේ නැහැනේ local investors ලා නැහැනේ. ඒක පිටරට අයට up to the percentage approved by the government කියලා කියන්නේ 100% ම allow කරන්න පුළුවන් government. හරි 100% ම invest කරන්න දෙන්න පුළුවන්. ඒ නිසා ඒකේ අර percentage එක specify කරලා නැහැ. ඒක මතක තියාගන්න. හරි පොඩි මේ එක. අනිත් ඒවා ගත්තාමත් මේ coastal shipping මේක මේ දෙන්නේ. පළවෙනි එකේ තියෙන්නේ fishing. පසු අල්ලන එක නේද? coastal fishing. මේ කියන්නේ shipping. Shipping industry the percentage is not determined. Yeah, they can invest right up to the percentage which is approved by the government. Right, lotteries, large scale mining of gems, right? Any industry manufacturing arms, ammunition, explosives. යුදෝපකරනවා කියන්නේ ඒවා ලංකාවේ හදන්නේ නැහැ නේද ඇත්තට දැන්ට නැහැ හරි ඒ වගේ වට අවස්ථාව දීලා තියෙනවා ඉතින් අර පොඩ්ඩක් ටික බලන්න දෙකේ මොනවාද මේ 100% restriction and 40% restriction and restriction only amount to the percentage which is approved by the government under third column. Right? So you need the industries වගේ හඳුනගෙන තියෙනවා. ඊට පස්සේ මේ විස්තරය තමයි මේකේ තියෙන්නේ. හරි ඔය chart එක බලා ගත්තාම නැති. මේ අනිත් එකේ තියෙන්නේ මේ විස්තරයම තමයි. මේක දෙකකින් බලා ගන්න පුළුවන් ඇත්තටම මේ chart එක. ඒකත් ගැසට් කරලා තියෙන ඇත්තටම මේ chart එක. මේ දෙවෙනි chart එක that is outflow investment. Right? The first one is inward investment. This is outward investment. One මේකේ there is table 1, right? Eligible resident investors. Right? So these are recognized as the eligible resident investors. Right? The company listed in Colombo Stock Exchange, or we can say listed company. If it is a listed company, they can invest in shares, units, debts, securities, and sovereign bonds. Right? The amount is mentioned under the third column, right? If it is a listed company, they can invest in shares, right? Right? 2 million, yes, 2 million US dollars. They can invest in shares in foreign companies only up to 2 million US dollars. 2 million US dollars. Where in India charging kilogram. Right? If it is a company not listed, unlisted company, then the restriction is 500,000 US dollars. Again, US dollars. Right? And partnership registered in Sri Lanka, then 300,000 US dollars. And individual persons, right? Natural persons, they can invest only up to 200,000 US dollars. And they can invest in shares of a company incorporated in abroad. Right. So only up to 200,000. Then thereafter, the last row, that is with regard to a company or a partnership that is not investing in shares. This is regarding setting up of overseas officers, right? Office එකක් හදන්න set up කරන්නේ, right? What is the amount? The amount is 300,000 US dollars, right? It is this permission is given only to the company or a partnership. If it is a company or a partnership, they can spend only up to 300,000 US dollars in order to setting up of overseas office, right? Setting up of a overseas office. So that is the second table, right? That is with regard to the outward investment. That's all, right? ඔය දෙක තමයි මේ මතක තියාගන්න තියෙන්නේ. ටේබල් එක බලන්න දෙන්න. මේ විස්තරي තමයි තියෙන්නේ. ඒක වචන වලින් විස්තරي තියෙනවා. හරි. කොහොමද මේ inward investment කියලා එකක්, inward investment, outward investment කියලා, there are two investments recognized. We don't regulate the foreign currency. Actually, there are some restrictions imposed. Right, according to the first table, it is with regard to inward investment. So as I mentioned earlier, actually in order to protect some industry, local industries, some restrictions imposed. So under first column, they cannot invest money in the company, carrying on business for pawnbroking and retail trade, postal fishing. And foreigners can invest only up to 40% in a company carrying on business for these industries, right? And the third column, it says the percentage is determined by the government, right? They can invest, but no specific percentage is given there, right? Take inward investment and outward investment. That is outflow of the money. Right? Right. ඊට පස්සේ then thereafter we can move on to the second act. It is named as Land Restriction on Alienation. Act number 38, 2014. Right? Alienation කියන්නේ alien කියන්නේ පිටස්තර කියන එක alienation. ඒ කියන්නේ විදේශිකයන් ඉස්සර විදේශිකයන්ට ලංකාවේ ඉඩම් ගන්න පුළුවන්. හරිද? ඒකේ stamp duty එක විතරක් double. දැන් අපි ගෙවන්නේ 1% නේ, එයා 2% ගෙවන්නේ. Then thereafter this act is enacted. According to this act, actually foreigners cannot hold land in Sri Lanka. They cannot hold land in Sri Lanka. නවත්තලා ගන්න 2010 වෙනකන් ගත්තා. ඊට පස්සේ මේ අනතය ගිහලා දැන් විදේශිකයන්ට ලංකාවේ දීපල අත්පත් කරගන්න බෑ. ඉඩම් ගන්න බෑ සරලව කියනවා. හරි. Then according to section 2 of the Act, foreign nationals foreign companies and Sri Lankan company of which 50% or more of its foreign shareholding. So if the foreign shareholding is 50% or more, they cannot hold land in Sri Lanka. Right? So now here actually we are discussing about the foreign shareholding. Now suppose there is a company incorporated in Sri Lanka and foreigners can invest money. If the foreign shareholding is the percentage is 50 or more, then they cannot hold land in Sri Lanka. And so here it says Sri Lankan company of which 50% or more of which foreign shareholding. So foreign investment is more than not more than 50 or more. 50 or more, they cannot hold land. Right? But if the foreign shareholding is less than 50, right, they can hold lands. Right? So there is the first now if the foreign shareholding is 50 or more than 50, right? 50% or more than 50%, then they can lease land for a period of 99 years. Maximum period is 99 years. අවුරුදු 99 දක්වා බද්දට ගන්න පුළුවන්. පැහැදිලිද? එකක් තියෙනවා. එකක් තමයි transfer deed by now ownership now. When we consider actually there are two types of deeds, right? One is known as transfer deed. Another type is known as lease agreement, right? So here now transfer deed means the ownership of the land transfer to a particular person. That deed is known as transfer deed. Now, as a person, a company can own a particular block of land, right? So by way of a transfer deed, right? So that is known as right transfer deed. And another one is now lease means actually it is two different concepts. There are two different concepts. One is ownership and possession. Ownership and possession. එහෙම දෙකක් තියෙනවා නේද? Ownership කියන්නේ එක. Ownership and possession. Possession කියන්නේ අපි භුක්තිය. භුක්තිය. Right? So if it is a lease, then what happens now? A is the owner of a property, right? Suppose he engages into contract with B to lease the property, right? Then under this lease agreement, actually what happens? The ownership is remain uniform. It is ownership remain with A, right? Only the possession is given to B. So if it is a lease agreement, we can name these A and B as lessor and lessee. Lessor and lessee. Right? Lessor has the ownership. Lessee will be given the possession. If පදිංචි වෙන විතරයි ඒක. IT වෙනසක් නෙමෙයි. So මේක 99 years වෙනකන් යන්න පුළුවන්. පරම්පරාවට දුන්නලද මක්කලද මොකේද? වරාය විදිහට අනුගමනය it is ownership එක දෙන්න බෑ. ඒක 2014 පස්සේ ඒක තිබුණාට බෑ. IT පවරන්න බෑ. Transfer means transfer means ownership transfer to other party. Then actually we name transferor and transferee. It is a transfer. These two parties named as seller and buyer. You can say transferor and transferee. Seller and buyer. Right? Ownership of the property. Ownership plus possession. Right? Ownership as well as the possession, right, is given to the buyer. That is known as transfer. Transfer or sale. That is known as sale. People know කියන්නේ ඉකිනීමකදී අපි කරන්නේ අයිතියක් දෙනවා, මුක්තියක් දෙනවා. හරි අපි ඉගෙන ගන්නවා කියන්නේ එයාට අයිතිය පවරලා දෙනවා, අපි අයින් වෙනවා. ඊට පස්සේ එයා තමයි මුක්තිය දෙන්නේ. හරි ගියා පාරින් කියනවා. බගාවට කියනවනේ ඒක කල ප්‍රයෝජන ගන්න. හරි පොල්ලා වගේ කඩා ගන්න ඒක තමයි බුද්ධි කියන්නේ ඒක. ඒක තමයි because the certificate තමයි lease. ඒක තමයි trans. lease එකේදී ownership එක මෙයා ගාමු තියෙනවා. Only the position is given to another. Like this, that is known as lease. So here actually according to this enactment, actually if the foreign shareholding is 50% or more, then that company cannot own land in Sri Lanka. Right? By way of a transfer deed, ownership cannot be transferred to that type of company. Right? If the foreign shareholding is 50% or more, cannot hold land. But they can lease land for a period of like 9 years. Understood? So that is the transfer deed and lease agreement. Right? Two different concepts. Right? In so this is with regard to the foreign shareholding is 50 or more. If the foreign shareholding is less than 50, less than 50, they can hold land in Sri Lanka. 50 or more cannot hold. Less than 50 can hold. Right? But only thing is, foreign shareholding is 50%. Therefore, there are two duties asked on registrar of lands and company secretary. There are two duties asked on registrar of lands and secretary. What is the duty of the land registrar? Right? He must get a confirmation, written confirmation from the secretary of that company. Right? In order to identify whether the foreign shareholding is still less than 50. In order to get that information, he must get a written confirmation from the secretary. And what is the duty task of the secretary? He must inform in writing, right? In writing in every 6 months period. 6 months period. In writing in every 6 months period, stating that the foreign shareholding of the company is less than 50. That information to be given by the secretary in writing to the registrar. Registrar must obtain that confirmation. Confirmation from the secretary of the company. They did not working. Make it a foreign shareholding in Aduna. ඒගොල්ලන් දුන්නා ඊට අත්පත් කරගන්න. හැබැයි හැම මාස 6කට හරි මේ රෙජිස්ටර් ගන්නකොට කන්ෆර්මේෂන් දෙනවා. foreign shareholding එක less than 50 කියන එක. Secretary of the company must inform that the foreign shareholding is less than 50 every 6 months period. Right? From the date of registration of the transfer deed. Right? Travel hopefully, ඉතින් අවරගත්ත දවසේ ඉඳලා මේ හැම මාස 6කටම සැරයක් එයා දැනුම් දෙන්න ඕනේ මේකේ foreign shareholding එක 50කට අඩුයි. ඒක බලන්න. ඕක දැනුම් දීගෙන අපරතුලිත එක පාර්ට්නර් එක 50 වුණොත් මොකද වෙන්නේ? foreign shareholding එක වෙනස් වෙන්න පුළුවන්. දැන් ඉතින් less than 50. Once it raised to 50%. Then whatever that transfer deed is automatically cancelled. Without umbrella, we right? You need to file an action. Automatically it is cancelled. Leave the fund other there. They ready to now make our umbrella. The transfer deed is cancelled. Right? So right. You know, India is a circle of right? Right. Sri Lankan company with less than 50% of foreign shareholding can hold. If the foreign shareholding is less than 50, can hold land provided such foreign shareholding remains less than 50 for a minimum period of consecutive 20 years from the date of the such transfer of land. Continuously, the foreign shareholding shall remain less than 50 for a minimum period of 20 years. That is the condition. On that condition, they can hold land. However, foreign nationals or foreign companies and Sri Lankan companies of which 50% or more of its foreign shareholding can lease land up to 99 years. Then responsibility of the company secretary under this act. Where the title of the land is transferred to a company incorporated in Sri Lanka under Companies Act, which is less than 50% of the foreign shareholding, it shall be the duty of the registrar of land to confirm himself by requesting the secretary of the company to submit documentary proof to the effect that the foreign shareholding of the such company is less than 50% of the total number of shares issued for the time being. So he must get a confirmation stating that the registrar of land must, the duty of the registrar is to get a confirmation from the secretary of the company stating that the foreign shareholding is less than 50. The secretary to the relevant company shall inform the registrar of lands in writing in every 6 months period, commencing from the date of the registration of the relevant deed of transfer, that the foreign shareholding of such company has not exceeded 50% of the total number of shares issued by the company. So there is a confirmation to be given by the secretary in writing in every 6 months period, right? Stating that the foreign shareholding is less than 50. Right? So there is the duty cast on the secretary. Okay, අපි අර එදා කතා කරපු එකේ මොකද්ද Securities and Exchange Commission Act එකේ අර අතරම ඉන්සයිඩර් ට්‍රේඩින් කියන කෑල්ල තමයි ඉන්සයිඩර් ඩීලිංග්ස් කියලා කෑල්ල කතා කරන්නේ. ඒක දැන් පොඩ්ඩක් හරි මොකද බලන්නේ. ඒක තමයි අතරම වැදගත් පාර්ට් එකේ. හරි අනිත් ඒවා නිකන් Colombo Stock Exchange එක ඊට පස්සේ අපි ආයේ කතා කළා Central Depository System CDS where their functions around the ඊට පස්සේ විදිහට හරි Foreign Exchange Commission Act and Land Restriction of Alienation. මේක තමයි තියෙන්නේ. ඊට පස්සේ මම අර කලින්ම ඔයගලන්ට දැම්මා දැන් ඉවරයි ඇත්තට. ඉවරයි අපි තව දවස් කීයක් තියෙනවද? සෙෂන් කීයක් තියෙනවද ඉතින්? දෙකක් වගේ නේ. මේකයි තව එක දවසක් තියෙනවා. තව එකක් ඊට අමතරව තියෙනවා. එක්සෑම් දාලා තිබ්බා නේද? මම දැක්කා. අපි මෙහෙම කරමු දැන් අද රෝම ඉතුරු වෙලාවේදී අර මේ මාගාව තියෙන සමරයක් මම දාලා තිබ්බා අප්ලෝඩ් කරලා බැලුවා. හරි ඒකේ අපි ආයෙ පොඩ්ඩක් කතා කරගමු මේක රිවයිස් වෙයි. කලින් කරපුවා ටික. ඊට පස්සේ අපි ඊගාව ඉතුරු වුණොත් දවසක් අපි එකට පේපර් එකක් කරනවා. හරි. ඒක පොඩ්ඩක් රෙඩියෝ දානවා. ඔයාලගේ EX එකක් තියෙනද අර අනිත් ඒවාට වැඩි පොඩ්ඩක් වෙනස් විදියකට දෙන්න. කරගන්න පුළුවන්. හරි. මොනවා හරි මේකයි අර පේපර් ඒක ඒ පැත්තෙන් කරන්න පුළුවන්. නමුත් අර විභාගෙදි ගිහිල්ලා ප්‍රමාණලාට ඒක පොදුවට යන ඒකත් එක්ක කරගන්න. අනවශ්‍ය දේවල් ඒවා ඊවෙන්න පුළුවන් නේ උත්තර තමයි පැටලෙන්න පුළුවන්. ඒ නිසා ඒක මග අරගන්න. ඒ නිසා පොඩ්ඩක් හොතට බලන්න. මොකක්ද හරි. අවුල් වෙන්නේ නැත්නම් කරන්නේ. මාර්ග එකක් ලියන්නේ තව එකක් අන්නේ ප්‍රශ්න තියෙනවා. ඒකෙදි ඇති කරගන්න. ඒක පොඩි නිකන් සාමාන්‍ය හරි ඇවරේජ් නොලෙජ් එකක් තියෙන්න ඕනේ. පොඩ්ඩක් මොකේද මේක අහන්නේ කියන එක බලන්න. හරි. මේ බලන්න පුළුවන්. ඒතර මේ මම මේ අර ලාලා තියෙන මේ සම්මරි එකේ ඒ ඔක්කොම ටික තියෙනවා. අපි කතා කරපු අතර මේකේ තියෙන විශේෂත්වය තමයි නිකන් එක පේජ් එකකට එක ටොපික් එකක් වගේ පාඩම් දෙකක් විතර ඒක වැඩිපුර කරන්නේ මෙජොරිටි රූල් එකයි වයින්ඩින් අප් කියන්නේ. අනිත් ඒවා ඔක්කොම හරි මේක ප්‍රින්ට් අවුට් එකක් ගන්න. මේක බලන්න. මේක බලලා ඊට පස්සේ කක්කරේ ගැටලුවක් ආවොත් නෝට් එක බලන්න. එච්චරයි. කරන්න තියෙන්නේ. ඕක කෙටි මතක තියාගන්න පුළුවන්. මේකෙන් පස්සේ හැරෙන මේක ප්‍රයෝජනවත් මොකක්ද වෙන්නේ? බැගින් දෙකින් බලලා සම්පූර්ණ වෙනකක් ගන්න. හරි. ඒ සෑහෙන කාලෙකින් හරපු එකක් මම. මේකේ වාසිය ඔයගලන්ට දෙනවා. රයිට් අපි මේකෙන් කොට අපි බලමු මේ මොනවාද මේ සාමාන්‍ය විභාගයේ අහන්න පුළුවන් ඇති. ගත්තාම දැන් අපි basically we are discussing about the operator, we are discussing about the provisions contained in the Companies Act. Right? So all the topics in relation to Companies Act we have mentioned here in the summary. Right? But I really not putting a something in our videos and the team I have queer team of right. Tapi balance. One of the get to one of the අහන්න නිකම් ප්‍රශ්න පාඩම් කරගෙන යනකොට පාඩම් කරගෙන පාඩම් නෙවෙයි නිකම් බලාගෙන යනකොට අපි නිකන් ගොඩ නැති දෙතුනේ අපි ඉස්සෙල්ලාම කතා කළේ corporate law වල person අද මම කියන ගැටලු ඇති වෙන තැන් මම අඳුරගත්ත විදිහට මම ඒ ටික ඒවා කොහොමද निराकरण කරගන්නේ කියලා ඒත් එක්ක අපි කතා කරගෙන යනවා. පොදුවේදී කොහොම ආයත ඇති වෙන ප්‍රශ්න මම දැකලා තියෙනවා. හරි. මේ පේපර් එක. අපි බලමු එතකොට now in our first topic that is incorporation. Under incorporation actually first we are considering about how to incorporate a company under the Companies Act. So before that, we have recognized there are two types of persons. Right? One is natural person, like you, right? Natural person means human beings like you and me, right? And legal persons. They are artificial legal person. Another name given to, right? Legal person. When we consider the legal persons, actually legal persons can be created. Actually, they are created persons. These persons can be created by two methods. One is Parliament can bring an act declaring a particular organization as a legal person. And the second way is by registration under the Companies Act. Actually, we are discussing how to incorporate a company, right, under Companies Act, right? In this topic, corporate law, right? In this subject, right, corporate law. So that is the way. The second way is by incorporation under the Companies Act. Right now, when we consider the incorporation, we can identify there are three types of companies can be incorporated. Yes. There are three types of companies can be incorporated under the Companies Act. Right. Yes. There are three types of companies can be incorporated: limited companies, unlimited company, limited by Galle. Very simple, right? Right. Then thereafter we have discussed about the procedure of incorporation. Another very important one, the procedure. You must have some sort of knowledge regarding the procedure of incorporation, right? So basically, we can identify there are 5 documents to be submitted to the register of companies in order to incorporate a company, right? 16A, application form 1, articles of association, form 18 and 19. That's all. So these are the documents to be submitted, right? So 16A, name approval form, application form 1, that is the application form, and articles of association, and form 18, consent of the initial directors to act as the director. 19, secretary, consent of the secretary. Right. So what happened when we submitting these documents to the register of company, then he shall enter the particulars of the company on a register, and the next very important one is assign a unique number to the company. And so this is known as company number. Unique number, assign a unique number to the company as its company number. And the next one is issue a certificate of incorporation. That is another very important document. So this is treated as the birth certificate. Right? It is similar to birth certificate. Right? Then certificate of incorporation is issued to the applicant company. Right? Then so first we have to submit documents to the registrar. Then what happened? Register, assign number, and enter the particulars of the company on a register, and issue certificate of incorporation. Then thereafter, the next step is within 30 working days after its incorporation, the company shall give a public notice. Right? The company has to inform it to public, right? By publishing an advertisement in a newspaper in 3 languages: Sinhala, Tamil, and English. So by that way, the company has to give public notice. That is important because now when we consider the name of the company under compulsory change, we have discussed after this public notice, within 3 months' time, if a company, right, has opposed to the name of the company, second registered company, then that first registered company can make an application to register, stating that the second registered company's name is uh, similar or identical to the first registered company. Then actually what happens, the registrar can direct the second registered company to change its name. Then within 3 weeks, 3 weeks, 6 weeks, 3 weeks time, it's the worker. During that period, the company has to change its name. That is, we have discussed under the compulsory change. Right? So that is very important. First, we have to inform the incorporation of the company to the public. Right? So here, the company has to mention the name of the company and the company number and address of the registered office. Right? By including this information, publish an advertisement in a newspaper. So that is known as public notice. Then that is the next step, right, after issuing the certificate of incorporation. Then thereafter, we have discussed about the legal effect of the certificate of incorporation. That is mentioned here. Legal effect, right? Another very important area. Now, once the certificate is issued to the applicant company, then this certificate or the birth certificate of this company is treated as uh, conclusive evidence, or we can say irrebuttable evidence of two things, two facts, right? Very simple, right? Irrebuttable evidence. That means, right, nobody can challenge these facts. Once the certificate issued, nobody can challenge these. The first one is the company has taken all necessary steps in order to incorporate it under the Companies Act. So, due to negligence, suppose particular step is not taken, but that is not invalidate the incorporation. Right? That mistake does not invalidate the incorporation. Therefore, this is conclusive evidence. That company has taken all necessary steps in order to incorporate it under the Companies Act. Then the second conclusive evidence is company came to an existence on the date which is stated in the certificate and not from any other date. Right? So date, like date of birth or the incorporation is uh, the date mentioned on the certificate. Nobody can challenge it. Right? So under that actually we have discussed about the one case, usually cotton mill versus device. In this case, actually due to an error, uh, the certificate says the date of incorporation is now suppose as uh, date of incorporation is mentioned as 1st of January. So we can say 5th of January. 5th of January. According to the certificate, it says 5th of January. Date of incorporation is 5th of January. But actually, the company was incorporated on 10th of January. Later, right? 10th of January. Then on 5th of January, company issue shares. Then this person, device, argue that the company on 5th of January, the company is not in existence. Therefore, the company cannot issue shares on 5th of January. The actual date is 10th of January, and not 5th, 10th of January. Erroneously mentioned as 5th of January. Therefore, he argued on 5th of January, actually the company is not incorporated, not in existence. Therefore, the company cannot issue shares on 5th of January. Right? But court came, right? Nobody can challenge it. If the certificate says 5th of January, the company was incorporated, then that is the date. That is the date of incorporation. Therefore, right, on 5th of January, this company can issue shares. Right? So that is the judgment given in this case. So there is conclusive evidence. Nobody can challenge, even though actually the actual situation is not like that. But nobody can challenge it by giving evidence. Nobody can rebut the presumption. Right? Nobody can rebut it. right? That is known as conclusive evidence or irrebuttable evidence of these two things, right? And that is the legal effect of the certificate of incorporation. Then thereafter, uh, actually we have discussed another very important concept, that is uh, the legal personality, or it is known as separate legal personality, or another name given to that, it is known as veil of incorporation. Veil of incorporation. That is another very important concept recognized under corporate law. That is, after incorporation, the company is separate from those who create it, own it, and manage it. You can identify, actually there are three parties. The person uh, owning it, the other shareholders or members of the company, right? Or manage it. Those who manage it, they are known as directors, right? Those who create it, create, first we have to say, create it, manage it, own it. Those who create it, those who manage it, those who own it, right? Create persons, actually we identify as promoters. Manage it, directors. It refers to directors. Own it, members. And so after incorporation, the company is separate person from those who create it, manage it, and own it. The company is one person, and directors, employees, promoters are other parties, right? They are separate persons, right? So for the activities of the company itself responsible, and not the directors, employees of the company are responsible for the activities of the company. So this is known as separate legal personality concept, right? Or legal personality, right? Or it is known as veil of incorporation. Veil means actually after incorporation there is a veil, right? There is a veil separating the company from the owners or directors or promoters, right? Therefore, actually, third party, because of the veil, third party cannot see beyond the veil, beyond the veil. Because of the veil, he cannot see, right? Who are behind the veil, right? Only the third party can see the company. Therefore, what happened? For the activities of the company itself is responsible, right? So if the company has taken a loan from a bank, then actually the company itself is responsible. The shareholders, directors, or the promoters, or employees of the company are not responsible to pay the loan, right? So that this concept is known as separate legal personality concept. But only thing is now, so this is the identifying the company as a separate person, right? This concept. Uh, Basically, when we consider this concept, identifying the company as a separate person, that is known as separate legal personality concept. But there are some exceptions recognized to the separate legal personality concept, right? Exceptions, right, are known as lifting of veil of incorporation. Now, as I mentioned, because of the veil, third party cannot see beyond the veil. Now, if we lift the veil, then what happens? Third party can see, right, who are behind the company, right, or shareholders. The third party can see shareholders, directors, employees of the company. So lifting means like making directors, shareholders, promoters responsible for the activities of the company. So actually these are known as exceptions to the separate legal personality concept. Right? So actually when we consider the exceptions or lifting of veil of incorporation, we can lift the veil of incorporation by two methods. One is according to the provisions contained in the Companies Act, that is under Companies Act. It is mentioned here as under Companies Act. And the second method is because of the case laws or case law principles. According to case law principles, we can lift the veil of incorporation. Right? So under the Companies Act, actually we have discussed about three sections. Section 12, 152, and 290. Right? Here actually the main use of the company name, right? Here, what happened actually, the company's name is erroneously mentioned on a document, which creates a responsibility. And later on, what happened, the company refused to admit that liability or responsibility, refused to admit it. Then, if the company refused to admit the responsibility, the person who signed the document, or suppose the check, right, erroneously the company's name is mentioned in a bill of exchange. Then the company refused to admit that responsibility, the person who signed the check is personally responsible. That will happen because of the name is erroneously mentioned according to section 12 of the Companies Act. And group financial account, mother company and subsidiary. So you got to prepare group financial accounts, then mother company and subsidiary. Subsidiaries are treated as an economical units, right? So remove the veil of incorporation and treat them as economical units. And solvency, on the Godakai Patlo, solvency. Solvency and solvency test, two different concepts. Solvency test කියලා කියන පරීක්ෂණයක් මේක. ඒක ඇත්තටම ඉන්ට්‍රොඩියුස් කරලා තියෙන මේ සමාගම් පන්ති. ඊට කලින් ඕක තිබ්බේ නැහැ. දැන් solvency කියන්නේ මොකක්ද? එතෙන්දි බලන්නේ මොකක්ද? දැන් solvency test එකේ we have to check two conditions. One is whether the company able to pay its debts in its ordinary course of business, and the second condition is the total value of the assets, right? Total value of the assets is greater than stated capital and liabilities, right? So in order to meet the solvency test, two conditions to be fulfilled. Right? First one is able to pay debts in its ordinary course of business, and the second condition, total value of the assets is greater than stated capital and liabilities. Balance sheet assets, total value of the assets. Under it was a liabilities stated capital. Liabilities behind. Total assets equal to liabilities. Reserves. Then we can say the second condition is we have to check whether reserves are available in the company. Right? Instead of that, we can say that, right, reserves available in the company. Then the company can meet the solvency test. Solvency it was a solvency test. Solvency solvency කියන්නේ අර පළවෙනි එක විතරයි ඉතන බලන්න. පළවෙනි condition එක විතරයි. Solvency means whether the company able to pay its debts in its ordinary course of business. Right? ඒකයි solvency. Now, ඔක apply වෙන්නේ අවස්ථා කීපයකදී. දැන් මේ solvency test එක හරිද? solvency test එක ඒ කියන්නේ fulfill වෙන්න ඕනේ සමහර වැඩවල. හරිද? මොනවාද ඒවා? Payment of dividend, reduction of stated capital, redemption of stated capital, redemption of redeemable shares, right? So, if the company unable to meet the solvency test, then the company cannot pay dividends, right? Or reduce the stated capital, or redeem the redeemable shares, right? The company has to meet the solvency test. ඒක පරීක්ෂණය. ඒක බලලා තමයි ඒවා කරන්නේ. ඒක හඳුන්වා දීම පරීක්ෂණය. හරිද? එතකොට මේ solvency කියන එකේ insolvency test insolvency කියන එකේ මොකද තෝරන්නේ? Again, now we have to check whether the company is able to pay its debts in its ordinary course of business. Then it is insolvent, right? Insolvent. Then what is the duty cast on the director? Now, actually, under section 290, duty cast on a director, right? That is known as solvency of the company. So, insolvency of the company. Yes. So, first we have to check insolvency kya hai na? Solvency means able to settle. इसका पूरा मतलब है settle. Able to settle. Able to settle debts. Unable to settle debts, insolvency. You can apply good not insolvency. Solvency can no good not. Solvency. Bankrot not. Able to settle. මෙතන කියන්නේ insolvency කියන. හරි insolvency it means right. So we have to take the solvency test and solvency. So insolvent means the company unable to pay its debts in its ordinary course of business. That is insolvent. Once right it is known to a director, he must immediately call the board meeting. ඒක හොඳට මතක ගන්න board meeting. That is the duty cast on a director. Immediately he must call a board meeting in order to decide board shall apply the board for winding up or further carry on the business of the company. If he fails to do so, then as a result of the company continues its business and liquidated, then that director is personally responsible to compensate the creditors. The personal liability imposed because of he not complying with the section 290. Right? There is the duty cast on a director. If he is not complying with that duty, then he is personally responsible to pay, compensate the creditors. Right? So this is happened under 219 of the Companies Act. That is known as insolvency of the company. Right? Only thing is, what is the duty? Immediately call a board meeting. There are two types of meetings. Don't say meeting, right? There are two types of meeting: board meetings and general meetings. General meeting means shareholders meeting. Here actually directors meeting to be called. Right? If he came to know about the unable to pay his debts, insolvent, then he must immediately call board meeting. Right? Board meeting. Then that is the duty. Only duty is calling a board meeting. Right? So that is the duty cast on the director. හරි ඒක පොඩ්ඩක් එම ඔළුවේ තියාගන්න. හරි solvency test and insolvency under section 219, two different concepts. Right? Then when we consider the case law principles, actually because of some case laws, we can reach the veil of incorporation. So here actually we have discussed about the two cases. One is the puppet company or sham company, and the second one is the court can lift the veil of incorporation because of national emergency. Right? So the puppet company, when we consider puppet company, another very important area, right? Here actually the puppet company means a company is incorporated in order to do an illegal activity. ඒක මතක තියාගන්න. රූකඩයක් නේ. puppet කියන්නේ රූකඩයක්. ඒ කියන්නේ නීති විරෝධී වැඩක් කරන්න තමයි මේ සමාගම පිටව ගන්න. රූකඩයක් විදිහට අටව ගන්න. ඒක අස්සට වෙලා වැරදි වැඩේ කරනවා. ඒකේ මුවා වෙලා. හරි ඒ සමාගමට මුවා වෙලා මෙයා නීති විරෝධී වැඩක් කරනවා. ඒක තමයි puppet. හැමතිස්සෙම මේක මතක තියාගන්න. right? So here actually they incorporate a company in order to do an illegal activity. So legally cannot perform particular activity, but in order to do that, incorporate a company. And through the company, that party has uh, done the illegal activity. Then actually court can lift the veil and identify who are the persons behind this company. Right? Then actually court can give a judgment against that parties in order to prevent these parties from doing that illegal activity. Right? So like that, only thing, main concept is after incorporation, through the company they are doing an illegal activity. අපි අර ඉතිරි අර සේවකී අයින් වෙලා කම්පැනි එකේ එයා ගිහිල්ලා සේවා යෝජනයක් කියන්නේ සේවකයා අයින් වෙලා රැකියාවෙන් කම්පැනි එක ෆෝම් කරලා කම්පැනි එක හරහා සේවා යෝජකයාගේ කලින් ඉන්න සේවා යෝජකයාගේ ගනුදෙනුකාරයොත් එක්ක කිසිම කරදරයකට පටන් ගන්නවා. ඒකත් වැරදි වැඩක්. Because according to the appointment letter, he cannot do that. But he resigned and thereafter he incorporated a company, and through the company he engaged into contract with the customers of the former employer. Then the court did the way and identify who is the owner, right? Or the director, main director of the company, and identify is the former employee. Then injunction order granted against him, preventing him from engaging into contract with the customers of the employer. ඒ විදිහට ඒක නවත්තන්න පුළුවන්. ඒක නවත්තන්නත් ඇත්තනම් ඒක හරි ඇතුලේ ඉන්නේ කවුද කියලා බලන්න පුළුවන්. ඒ අධිකරණයේ මේ බලය තියෙනවා. මොකක් හරි අතන නීති විරෝධී දෙයක් නම් වෙන්නේ අනිවාර්යෙන්ම ඒක ඇතුළ පරීක්ෂා කරන්න හැකියාව තියෙනවා. කවුද ඇත්තටම මේක මෙහෙවන්නේ කියලා. මෙයා ඇත්තනේ මෙහෙවන්නේ. නීතිය අභිභායන්න බෑ. එහෙම සමාගම වැරදි විදිහට පාවිච්චි කරන්න බෑ. ඒ නිසා ඒක මතක තියාගන්න අනිවාර්යයි. හරි. Incorporate a company in order to do an illegal activity. Illegal activity. Illegal තමයි ඒකේ අපි කතා කරන්නේ. ඊට පස්සේ හරි ඒක ලේසිනේ. හරි ඒක ගොඩක් වෙලාවට ප්‍රශ්න අහන්නේ පළවෙනි දෙවෙනි ඕකේ. හරි ඒක incorporation. Because lifting of veil of water. Legal personality concept, thereafter lifting of veil of incorporation. Sarla, karma the basic. Then we have discussed about the articles of association. Another very important area. So here, article is the constitution. It can be treated as the constitution of the company, right? And so when we consider the articles of association, there are several sections. We have considered section 30. Section 13, according to the section 13, it says articles of association may set up. That word is very important. May set up. May set up means may, when we consider this word may, that is optional. May set up. It means not compulsory. Not alone. Not compulsory. Not compulsory. May. Shall and may. May කියන වචනේ අපිට හම්බුණා දැන් දෙකකට. මතකද? මේ අපි කරගෙන ආපු පාඩම දැන් දෙකකදී හම්බුණා. මේ වචනේ ඒ විදිහට මතක තියාගන්න. හරි එකක් තමයි මෙතන. May set out objects, rights and obligation of the shareholders. Provision with regard to management and administration, any other provision not violating the company's act may set up in the articles. I want to example. Pre-incorporation contract. Now, Reincorporation contracts may be ratified. May be ratified. After incorporation, the company may be ratified. It means the company either can ratify the contract or refuse to ratify the contract. So here also may set out. It means the company may setting out the objects or avoiding from setting out the objects of the company. May set out. But that is not compulsory requirement. Right. So these are the content of the articles of association. Then thereafter, uh, yes. So here also it is mentioned setting out the objects is not compulsory requirement. It is not compulsory because of the word may. But when we consider the practical situation, right now, basically we can identify there are uh, three main types of companies. One is uh, public company. Now, basically, we divide the companies into three, right? Limited, unlimited, and company limited by guarantee. Three companies can be incorporated. Limited companies, we can further classify it as public and private. Public companies further classified as listed and unlisted. There is the classification. Now, when we consider public company, their main feature is they can invite the public to purchase the shares. Right? So, in order to invite the public to purchase the shares, they will publish an advertisement in a newspaper. It is known as prospectus. So, in the prospectus, these companies must mention their objects. Right? Must mention their objects. That is the one requirement. And as far as concerned the third type of company limited by guarantee, section 34 specifically mentioned if it is a company limited by guarantee, it shall, that word is shall mention its objects. Right? So compulsorily they have to mention their objects if it is a company limited by guarantee. Right? So may set out that rule will basically apply only with regard to private companies. So that concept we have recognized according to some other related provisions contained in the Companies Act. Right? Then thereafter, then the most important area is ultra-virus transactions. Right? Product by ultra-virus concept ultra-virus rule කියන එක සමාගම් පනතෙන් අයින් කරලාද තියෙන්නේ. සමහර මට ඇත්තටම කෙනෙක් කියනවා මොකටද ඔබ ගන්නන්නේ කියලා. ultra-virus rule එක. ඒ වගේ ඉවරයි කියලා දැන් නෑ නේද? ලෝය කෙනෙක් කිව්වා. ultra-virus rule එක අයින් වෙලා තියෙන සමාගම්. අයින් වෙලා නැහැ. ඒකයි මේ උගන්වන්නේ. අයින් වෙලා නැහැ. හරි. අයින් වෙලා නැහැ. ඒක අයින් වෙලා නැහැ කියලා අපිට පේනවා. මොකද තමයි effects of ultra-virus transaction. There are two effects. One is before engaging to ultra-virus transaction, any shareholder or company can bring an action in order to prevent the company from engaging into that ultra-virus transaction. If it is permitted, then how shareholder can prevent the company from engaging into ultra-virus transaction. Right? Therefore, actually, it is admitted. That's why that right is given to the shareholder. There, make effects. අපි අන්තිමට කතා කරේ effects බලන ultra-virus transaction එකකට යනවා නම් shareholder කෙනෙකුට පුළුවන් අධිකරණයේ ගිහිල්ලා නඩුවක් දාලා ඒක නවත්තන්න. Before engaging to the ultra-virus transaction, any shareholder can prevent the company from engaging into ultra-virus transaction. ඒ කියන්නේ අර ultra-virus rule එක admit කරලා තියෙනවා. නැත්නම් එහෙම අයිතියක් දෙන්නේ නැහැ shareholder කෙනෙකුට. ඒක බලන්න අයින් කරලා ඉතින් අයින් කළා කියන්නේ එන සමාගමට පුළුවන් ඕනම කිවිසුමකට ඇතුළත් වෙන්න. ඒ අයිතිය තියෙනවා. හරි එහෙනම් මේව නවත්තන්න හැකියාවක් නැහැ. හරි මේව නවත්තන්න පුළුවන් කියලා මේ කියන එකෙන් තේරෙනවා අල්ට්‍රා වයලස් රූල් එක තාම තියෙනවා නෑ වගේ නිකන්. එහෙම හරි තිබුණාට නෑ වගේ යන්නේ එහෙම නිකන්. කරමෙන්නත් එක තමයි තියෙන්නේ. ඒක තියෙනවා. ඒක පේනවා අර effects of. හරිද? Any shareholder can prevent it before engaging into ultra-virus transaction. After engaging into ultra-virus transaction, if the company suffers any loss, then directors are personally responsible to compensate the company. So again, that concept is admitted, indirectly admitted. But only thing is when we consider the section 17 subsection 1 and 17 subsection 2, it says, now 17 subsection 1 it says, right, they are the objects mentioned in the articles of association, then company and management shall restrict their transaction only according to the objects of the company. Right? So it is very obvious that ultra-virus rule is admitted by section 17 subsection 1. But 17 subsection 2 says, right, all the transactions, and further it says actually the power and capacity of a company cannot be restricted by its object clause. Therefore, all the transactions are valid and enforceable. Right, valid and enforceable. Right. By section 17 subsection 1, the rule is admitted, and thereafter it says all the transactions are valid and enforceable. Right? It says valid and enforceable. Right? But actually, the rule is not eliminated. It is not removed by the provisions. But when we consider the effects, it is very clear. Before engaging into ultra-virus transaction, any director or shareholder can bring an action in order to prevent the company from engaging into ultra-virus transaction. Right? However, now when we consider the reason is, right? Reason is very clear. Actually, the objects are mentioned in the articles of association. Actually, the affairs of the company must be restricted according to its objects. But only thing is, the freedom is given to the company, right? So that is given to the actually directors, right? They can have proper decision, and even though the transaction is not complied with the object clause of the company, they can engage. After engaging into that type of competitive transaction, they can earn profit. They need not to limit their transaction with their object clause. They can engage into ultra-virus transaction, right? Then out of that ultra-virus transaction, the company gain profit, then it's okay. But only thing is, the risk is given to the directors, right? Out of that ultra-virus transaction, if the company suffers loss, then directors are personally responsible to compensate the company. Right? अन्य अवस्थाओं में दीला तीन यार तारक कराने वाले अवस्थाओं दीला तीनों परमार्थ तीनों ना इवन टाइमों ताकि कराने के लगी अबे आई इंदन तीनों ये मत युवा हम देखो वाला उनका इतना तीन वैली इंटेंट इन्फोर्सेबल ये कि ultra-virus transaction का तुम ये क्या है परमार्थ वाला रहती है कि विश्व में परमार्थ रहती ගම්බිනු වලට ඇතුළත් වෙලා හරි සමාගම ලාභෝප වෙනවා නම් කමක් නැහැ. ඒක ප්‍රශ්නයක් නැහැ. හැබැයි එකම දේ පාඩු ලැබුවොත් ඒක අවදානම දෙන්නේ කාටද? ඩිරෙක්ටර්ස්ලා. ඒකට විරුද්ධයි. පරිලාකක් නැති දේවල් කරන්න ගිහිල්ලා පරමාර්ථවල නැති දේවල් කරන්න කියලා පාඩු ලැබුවොත් පාඩුව ඩිරෙක්ටර්ස්ලා පුජ්‍යලිකව සමාගමට ගෙවන්න ඕනේ. කියලා කියනවා. ලාභයක් වුණොත් ප්‍රශ්නයක් නැහැ. පාඩුවක් වුණොත් තමයි ඒගොල්ලන්ට වගකීමක් තියෙන්නේ. ඉතින් මේ එක දීලා තියෙන ඒගොල්ලන්ට රිස්ක් එක දීලා තියෙන ඒගොල්ලන්ට ඩිරෙක්ටර්ස්. ඒක ඇති කරන්න තමයි අර section 17(2) ඇවිල්ලා තියෙන්නේ. හරිද? ultra-virus rule is admitted, but in order to give that opportunity freedom to the directors, then section 17 subsection 2 is introduced. It's very clear because of the effects of the two effects we can identify on the ultra-virus transaction, right? So according to this. The second effect, if the company suffers any loss, directors are personally responsible to compensate the company. Right? They gain profit, it doesn't matter. There's no any effect. Right? ඒ විදිහට තමයි දීලා තියෙන්නේ. කවර යන්න අවස්ථාව දීලා තියෙන්නේ. Right. ඉතින් ඕක තමයි අල්ට්‍රා වයලස් රූල් එකේ තියෙන ප්‍රශ්නේ. ඒක දැන් ඔය අපි කතා කරන්නේ corporate law එකේ කියන්නේ අපේ companies act එකේ තියෙන provisions. මේක මුලින්ම ආවේ ඒක මුලින්ම කියන්න ඕන එකක්. මුලින්ම ආවේ common law එකේ. Ultra vires rule එක. Ultra vires means company can mention their objects, right? Company can mention its objects in the articles. Then if the company mention its objects in the articles, then they can engage into transactions according to the objects. If the company engage into transaction beyond the objects, then beyond the scope, then that type of transactions are known as ultra vires transactions, right? This concept, according to the common law, right? Common law, ultra vires transactions are treated as void contracts. Void, no value from the beginning. Void contracts, right? Reason is now actually the restriction to be introduced in order to give protection to creditors and shareholders. That's why they have introduced this rule, right? So the case law. Ricky versus Ashbury Railway Company Limited, we have discussed that. Just mention the name. In this case, actually, this concept is introduced in order to protect the shareholders and creditors. Right? So, beyond the object clause, all the transactions beyond the object clause to be treated as void contracts. So, there is the known as ultra vires rule. So, ultra vires transactions are void. The same concept comes to here, Companies Act. It is accepted by the section 17, subsection 1, and further it says even though it is ultra vires transaction valid, but we can identify there are two effects, right, of the ultra vires transaction. So that is discussed under the Articles of Association. Right. Actually, when we consider the articles of association, we have to consider two parts. One is about the ultra vires transaction, and the second one is another very important one. That is the effects of the provisions contained in the articles. Right. Eka godak that පැකිලෙන එක. හරි දැන් මේ ව්‍යවස්ථාවලියේ සඳහන් කරලා තියෙන කරුණු වලිනුත් යම් බලපෑමක් ඇති වෙනවා. එකක් තමයි now when we consider the articles of association, it may contain right objects. Section 13 says objects, rights and obligation of the shareholders, right? Management and administration, provisions with regard to management and administration, any other provision not violating the Companies Act, right? So very vast scope given to the articles of association, right? So when we consider the provisions contained in the articles of association, right, we can categorize these provisions. Some provisions are related to his capacity as shareholder. The provisions ගත්තහම articles වල තියෙන අපි ඒවා කොටස් දෙකකට බෙදන්න. Capacity as shareholders, capacity as directors, accountant, lawyer, when we consider the provisions, right? When we consider the provisions contained in the articles of association, we can divide the provisions into two. Some provisions are related to his capacity as shareholders. Some provisions are related to his capacity as director, accountant, lawyer, right? Secretary, or whatever, right? Other than shareholders. Then what happened? By these provisions. By the provisions, in relation to his capacity as shareholder, binding contract for. Right? Contract for. Here, by these provisions, only by these, only by these provisions, contract form, we can identify there are two types of contracts. One is made between shareholder and the company, and shareholder and the other shareholders of the company. Two types of contracts. Right? Right? The provision is related to his capacity as shareholder. Contract form. Right? It may be the contract may be formed between shareholder and the company, or single shareholder and the other shareholders of the company. Right? Shareholder and other shareholders of the company. But by the provisions, his capacity as director, accountant, no contract form. No contract. Again, may අපි ගත්තා මේකේ අන්තර්ගතය කාටු ගත්තාම ඒක සමහර ඒවා කොටස් හිමියෝ විදිහට ලැබෙන දේවල්. කොටස් හිමියෝ වීම මත ලැබෙන දේවල්. කොටස් හිමියෝ නොවන වෙන හරි තව ඉන්නෝනේ අධ්‍යාපකවල ඩිරෙක්ටර්ස්ලා ඒගොල්ලෝ වීම මත ලැබෙන දේවල්. මේ රැයි කොටස් හිමියෝ වීම මත ලැබෙන යම් දේවල් වලින් හරි කියලා විවිධාන වලින් ඇත්තටම කිවිසුමක් වෙනවා. මොකක්ද කවුරුද කිවිසුම නැන්නේ? ඒකෝ මේ කොටස් හිමියා සහ සමාගම අතර වෙනවා. එහෙම නැත්නම් කොටස් හිමියා සහ විවිධ කොටස් හිමියා අතර කිවිසුමක් වෙනවා. කිවිසුම හැදෙන්නේ නෑ. අන්න ඒක තමයි මම කියන්නේ. උදාහරණයක් විදිහට අපි ගත්තේ according to the articles, it says every shareholder is entitled to cast 1 vote per share. 1 vote per share. This is the articles. It says every shareholder is entitled to cast 1 vote per share. And further it says, another provision, it says every director is entitled to receive 100,000 rupees per month. Per month. So this provision, right, it is related to his capacity as a director. The second provision is related to his capacity as a shareholder. Right? So by this provision, only by this provision, binding contract, right, between company and the shareholder, right? Or binding contract may be formed between single shareholder and other shareholders of the company. But by this provision, no contract formed between director and the company. Therefore, even though the company refused to pay, now articles is the supreme law in the company constitution. Lanka supreme law is supreme cabinet. ඒක වයලේට් කරන්න බෑ. පාර්ලිමේන්තුවේ ඕන පනතක් ගේන්න පුළුවන්. ඕනම පනතක් ගේන්න පුළුවන්. ආණ්ඩුක්‍රම ව්‍යවස්ථාවට පටහැනි නොවේ. Right? Not violating the provisions contained in the Constitution. Parliament can bring any act. Right? By repealing existing act or by repealing judgment Even by the Supreme Court, even right, Supreme Court. දේශපාලනිකව තීන්දුව පවා ප්‍රතික්ෂේප කරමින් ඒක පටහැනිව ව්‍යවස්ථාවක් කියන එකම පාලනය. ව්‍යවස්ථාවක් තියෙන ව්‍යවස්ථාව අවලංඝනය කරමින් පනතක් කියන එක පාලනය. මේක අවලංඝනය කරන පාලනයක් තමයි. හැබැයි එකම දේ මොකද? කන්ස්ටිටියුෂන් එකට පුත් කරන්නේ. ඒක හැරෙන්න අනිත් ඕන එකක් වෙනස් කරන්න පුළුවන් පාලනය. ඊළඟ සුප්‍රීම ලෝ කියන ඒ වගේම තමයි මේ සමාගමක් ගත්තා ඒකේ ඉහළම නීතිය මේ articles of association. ඒකේ තියෙනවා every director is entitled to receive 100,000 rupees remuneration. Okay. Suppose the company refuses to pay him 100,000 rupees. Right? Director cannot bring an action against the company in order to claim damages on the basis of breach of contract because by this provision no contract form between company and the director. But here by this provision, by the contract form between company and the shareholder. Suppose this particular shareholder, his voting right is not properly accepted by the chairman of the meeting, then this company can bring an action against the company in order to claim damages on the basis of breach of contract. Right? So because of this provision, by the contract form between company and the shareholder. Right? So that is the main reason, right? So only thing is there are several provisions may be contained in the articles. Then we have to consider whether it is related to his capacity as shareholder. Only by these provisions, contract form between company and the shareholder and the company, single shareholder and the other shareholders of the company. By these provisions, no contract. So even though these provisions are violated by the company, they cannot bring an action. The use of Karuna Dela and Nadua gave it that. You know, Lanka Dela, Nadua gave it that. So the use of Karuna and ultra virus transaction and the provisions containing the articles. We have to consider new things in relation to articles of association. වතුර කැපීලේ අමාරු ඉන්නේ Galle aku. Yeah. Like then that is about the articles of association. Thereafter, yes, promoters, right? So now when we consider the promoters, they are the person uh, who are taking necessary steps in order to incorporate a company. Right now, when we consider this topic, actually basically we have to consider about the pre-incorporation contracts, right? Because now, uh, according to law of agency, right? According to law of agency, pre-incorporation contracts cannot be ratified, right? Even though the pre-incorporation contract is ratified, it is invalid, right? So the common law concept is pre-incorporation. Company cannot ratify its pre-incorporation contract. So we need to consider the meaning of the pre-incorporation contract. That is, like now, pre-incorporation contract means promoter engaging to contract with third party. Suppose 1st of January. Then thereafter the company was incorporated. Suppose the company was incorporated on 5th of January. Then thereafter, on 7th of January, the company has ratified the contract. So this is the date of incorporation, that date of ratification. This is the date on which promoter engaged in contract with the company. So now what happened on 1st of January, the company is not in existence with contractual capacity. Right? On 1st of January, the company is not available. Right? Therefore, even after the company is incorporated, the contract is ratified. This ratification is invalid. It means no contract made between company and the third party. Company and third party. No contract formed between company and third party. Right. So this is the concept recognized under law of agents. Right? Therefore, actually we can say now this contract promoter engaged into contract with third party on 1st of January. Therefore, on this day the company is not yet incorporated. Therefore, it is known as pre-incorporation. Pre-incorporation contract. Right. Pre-incorporation contract. According to the law of agents, it says a company cannot ratify its pre-incorporation contract. So this is the concept recognized under law of agents. But what happens under the Companies Act? Companies Act, it says, section 23, it says, right, notwithstanding anything to the contrary in any law, right, pre-incorporation contracts may be ratified. Right. Again, here may be ratified. The word used may be ratified. Therefore, actually the company can ratify the contract or refuse to ratify the contract. There is optional, not compulsory. Therefore, now because of these wordings, right? Now, if the company ratifies the contract, the company says after ratification, the contract is pre-incorporation contract is valid and enforceable. Valid and enforceable as the company was being a party to the contract on the day promoter engaged in the contract with third party. From this day, now after incorporation, after ratifying the contract, then the contract is valid as company was being a party to the contract. Right? On the day promoter engaged in the contract with third party. Right? So that is the effect. If the company after incorporation ratify the contract. But here it says may pre-incorporation contract may be ratified. Therefore, right, by entering into contract with third party, promoter gives two warranties. Two warranties. Right? The first one is with regard to incorporation. Right? The first warranty given by the promoter to the third party, the company on this state promoter engaging contract with third party. Then the promoter gives a warranty to third party that the company will be incorporated in near future. Right? That is the first warranty. And the second warranty is now company incorporated. Then thereafter ratified. After incorporation, company has to ratify. But here may be ratified. Therefore, the company may sometimes company may refuse to ratify. Therefore, the second warranty is after incorporation, company ratify the pre-incorporation contract. So that is the second warranty. That is with regard to ratification. So there are two warranties given by the promoter to the third party when engaging into pre-incorporation contract. Then actually what happens if the company is not incorporated, or even the company is incorporated, it refuses to ratify the contract. Then what happens? Third party is entitled to recover damages from the promoter. If it is ratified, then it's okay. But if the company is not incorporated, or after incorporation refuse to ratify, then third party can recover damages from promoter on the basis of breach of warranty. Two warranties given, then on the basis of breach of warranty, he is entitled to recover damages. That was happened with regard to pre-incorporation. So according to the law of agency, the ratification, pre-incorporation contracts cannot be ratified. That is the law of agency, according to law of agency. But according to the Companies Act, right, pre-incorporation contract may be ratified. After ratification, it is valid and enforceable. But only thing is, by entering into pre-incorporation, two warranties given by the promoter. On this regard, in relation to incorporation of the company. The second warranty is given with regard to ratification. That's so. That is the most important area in the companies. Right? Promote and pre-incorporation contract. Then thereafter, ගොඩක් අය වරද්දට එකක් තමයි මේක. මේ meetings and resolutions. ඒක පොඩ්ඩක් මතක් කරගන්න. meetings meeting කියනවා දැන් මාකරි ප්‍රශ්නකට උත්තර දෙන්නකොට උනා meeting එක මොකක්ද කියලා කියනවා. හරි meeting එක there are two types of meetings. පොඩි නිකන් සමගියක් කියනකොට meeting and resolution එකට ගන්න පුළුවන්. කතා කරන්න. ඒක සරල දෙයක්. Right. When we consider the meetings, there are two types of meetings: directors meeting, shareholders meeting. Two types of meetings. Right. Shareholders meeting we can divide into two. Right? AGM, annual general meeting, and extraordinary general meeting. Right? AGM and meeting. In order to call an AGM, not less than 15 working days notice to be given. Right? Not less than 15 working days notice. to be given. But in relation to ETA, right, 10 and 5, public, private, right, 10 and 5 working days, right, 10 working days, 5 working days notice to be given. Right? In a public company, you don't call an ETA not less than 10 working days notice to be given. In a private company, right, at least 5 working days notice to be given. Right? So these are the meetings of shareholders. So at the meeting, as the name, there are two types of resolutions can be passed. Two types of resolutions in AGM or EGM. Right? Two types of resolutions. Right? One is ordinary resolution, special resolution. Here also ordinary, special. Right? Well, कोई भी debate ना ordinary resolution, special resolution. Ordinary ordinary special the data how we can decide which type of resolution to be passed in order to take a decision. Take a reform. Take a meeting manual email. Meeting AGM का EGM का लगेगा का आधार EGM का क्या है हादिसे क्या है AGM वन से बीच क्या है AGM annual general ये आता है तो बात करने वाला EGM क्या है हादिसे का ये वेंडर बोला कि आप आउट द परागी करते हो एक प्रोडक्ट का तो ऐसे ही पास से में स्पेशल तो मतलब कि रेजोल्यूशन के में एक अकेले में का कंपनी सेक्रेटरी and if the company says special resolution required to take a particular decision, then we have to pass a special resolution. All the other resolutions can pass by an ordinary resolution. We got the alter the articles or change the name, company name, alter the articles of association, change the company name, right? Approve major transaction, approve amalgamation, right? Company's access, right? Special resolution request. Special. Apart from these, all other resolutions can be passed, right? As an ordinary resolution, right? So here we have company's access, special resolution request. Then we have passed special resolution. Now, when we consider the special resolution means a resolution which is passed by majority of 75% of votes after giving not less than 15 working days notice. And a resolution which is passed by not less than resolution which is passed by majority of not less than 75% of votes after giving right 15 working days notice. Not less than 15 working days notice to be given. The method of the EGM. As I mentioned, 10 and 5 working days notice can be given in order to call an EGM. So in an EGM, suppose the special resolution is going to be passed, then what happens? 10 and 5 working days notice is not enough. Right? But then EGM, company wants to pass a special resolution, then not less than 15 working days notice to be given. 15 working days notice. Even though it is an EGM, not less than 15 working days notice to be given. And better than the ordinary resolution එකේදී ඒක කාලයක් කියන්නේ ව්‍යවස්ථාව. ඒක අපිට after giving 5 working days notice, company can propose and pass a resolution as an ordinary resolution. ඒක better than 15 working days notice එකක් දෙන්න. 15 working days notice එකක් දෙන්න. තවත් වෙනස අල්ලගලා අපි වෙලාවකට 15 working days notice එකක් දෙන්න බැරුවොත් තවත් විදියකට මේක සම්මත කරන්න suppose only 10 working days notice able to give. How company can propose and pass a resolution as a special resolution. It's another way actually introduced under the companies. That is, suppose due to some reasons, company unable to give not less than 15 working days. Company has given less than 15 working days notice and more people. Right? At the meeting, company wants to propose and pass a resolution as a special resolution. How it can pass? By majority of here, normally by majority of 75% of votes, that resolution to be passed. If company has given less than 15 working days notice, then by majority of not less than 85% of votes. Right? By majority of 85% of votes, company can propose and pass a resolution as a special. පහලතොල කාලයක දැනුම් දීමක් කළා නම් අර ප්‍රතිශතය වෙනස් වෙනවා 10 ඉස්සර 75 පස්සේ 10 එහෙම ඒක සම්බන්ධ කරගෙන proposal pass right by majority of 85% ඒක බබල් කරගෙන percentage කරන් ඇපිලිටි පාස් පහලක දැනුම් දීමක් කරන්න බැහැ පාස් පහලක දැනුම් දීමක් that EPA, the company wants to pass a special resolution, 15 working days notice to be given. Further, it says if the company are able to give less than 15 working days notice, the company can propose and pass a resolution as a special resolution by majority of 85% of votes. ये हम पता करेंगे वो मुझे वीडियो ना इसी शास्त्र के असूल AG and EGA, two types of resolutions. Ordinary, this is simple majority of votes, more than 50% of votes. Ordinary resolution. By majority of 75% of votes after giving 15 working days. We are able to give 15 working days notice, 85% of votes. So by that way, company can pass resolution. Then now here AGM, EGM, identify as shareholders. Another way, company can take decision that is without a meeting, no meeting, by way of a written resolution. Written resolution. Without calling a meeting, by way of a written resolution, company can take decisions. Right? How company can pass a resolution? Written resolution. A resolution in writing signed by not less than 85% of shareholders. Not less than 85% of shareholders. So first condition refers to shareholders, persons. Suppose there are 5 shareholders in the company, then each shareholder represents 20%. Right? Not less than 85% of shareholders. Right? And the connecting word is and shareholders together holding not less than 85% of voting rights. The resolution in writing signed by not less than 85% of shareholders and who together holding not less than 85% of voting rights is valid as if it is passed at a general meeting. Right? Second condition with regard to voting rights. Votes. Right? Voting rights. Both conditions to be fulfilled. There are two conditions. Both conditions to be fulfilled. First and second. Right? Not all. And right? 85% of shareholders and they together holding not less than 85% of voting. Two conditions to be fulfilled. At the same time, two conditions to be fulfilled. Obviously, they come some food. එතකොට තමයි ඒක සම්බන්ධ ඒක අසන්න ගන්න වැලියු එක. බලන්න ඒකම තමයි නේ. මෙතන තියෙන percentage එකම නෙමෙයි. මෙතන තියෙන percentage වල එකක් තියෙනවා. මට එළියගෙන ඒක සමානයි ඒක 50 75 මෙතන 85. මේ percentage එක හොයන්නේ හැම විදිහේ 85% of shareholders. 85% of voting. And voting. ඒක ටිකක් අමාරු දෙයක්. දැන් අපි මේකම අපි හිතමුකෝ each person represents 20%. And there are the voting rights 20%. 20%. 20%. 20%. चलो बार बहुत रेसोल्यूशन में क्या प्रोग्राम ये नहीं दिया था ऐसा भी बोलो आसान करा उपवास बंद करा दिया ये जब बेटी के राहुल है ये उपवास करता तेरे ये 85 मिनट कंप्लीट है मेरा लेकिन अब फुलफिल करा तो मेरा एक तरह आसान कर देता आगे क्या करो और दे दे 9 जब निकल ले और ये पूरी देना all these shareholders must sign otherwise they cannot pass it and it is up ya daddy and itu sama pun kan nama dia kalau bilang kan orang sama kan वो नहीं बोला था कि कितने दिन बाद आ गया Agreement के तमाम ये कितनी है resolutions meetings and resolutions thereafter, maybe company secretary के पॉडी पार्टन आते हैं ये पॉड डबल हुआ මේකේ legal position කියන එක තමයි බලන්න තියෙන්නේ legal position of the secretary හරි මේකේ අතරම මේ සුදුසුකම් තියෙනවා ආවා මේවා ඒකත් නිකන් පොඩ්ඩක් නිකන් බැලුවොත් like the annual turnover is 1 million or more and the stated capital is 500,000 rupees or more, then qualified person to be appointed as the secretary of the company. Right? Then legal position, when we consider the legal position of the secretary, then actually two cases we can consider. One is old one and another the new case also we have discussed, like Panorama Developments versus PDA. Right? Actually, what happened under these two cases? එකක් ඔය පටලව ගන්නවා කට්ටිය. මොකක්ද කියන්නේ අද දෙකේ? නේ? AC. Authority can be divided into three. Authority of a person. Express, we can divide into actual, then actual can be divided into two as express implied. Right? Three, we can divide into three as express implied and apparent. Or we can say actual authority can be divided into as express and express means authority given to a person in writing or orally. In writing or orally. Express. Implied. Apparent. These two, express and implied, right? They are treated as actual authority. Actual authority. Right now, what happened in the first case, it says the secretary of the company has only actual authority. Only actual authority. So in other words, he has no apparent authority. And he can do what he is told to do. He will in writing orally, or he can imply some activities and he can perform this. And he can do what he is told to do. Expressly or impliedly told to do. And he has no apparent authority. Apparent කියන්නේ මොකද? Apparent කියන එකේ තියෙන්නේ apparent කියන්නේ පේනවා කියන එක. පේනවා. It appears to another part. Appears. Apparent. And the way කියන්නේ සත්‍ය actually සත්‍ය කියන සත්‍ය බලය. ඒ කියන්නේ යාට ලිඛිතව වාචිකව. එහෙම නැත්නම් යාට හිතා ගන්න පුළුවන්. ඒවා තමයි සත්‍ය බලය කියන්නේ. the following ability that he has no apparent authority. And he has no, secretary has no apparent authority. No apparent authority. Apparent can pay now. Part of the baby. Part of the baby. The Malay baby. Our secretary का baby कराने पूरा फिर तीन में काट. It appears third part. Third part. Baby was the partial to company secretary third part. Actual authority का दूसरा नाम न्याय देखना बताना ये देखना धर्मा तो ना या actual authority का दूसरा इधर पास है apparent authority क्या है न्यायावा दीपे का ठीक है no actual authority but it appears to third reasonably appears to third party that the secretary can engage in this contract. It appears to third party. So that is known as apparent authority. So first case is right. Secretary of the company has no apparent authority. Second case, Panorama development case. Second case, it says secretary of the company has apparent authority. Right? He has apparent authority which are purely administrative. Administrative. First case is he has no apparent authority. He can do what he is told to do. Second case is he has apparent authority without purely administrative measures. Further, it says the secretary of the company is the chief administrative officer. He can do what he has, or the third party can imply that he has authority to do activities which are purely administrative measures. It means actually he has apparent authority to do activities which are purely administrative. Right? Apparent authority. He has apparent authority. No apparent authority. Later on, God decided he has apparent authority. I mean,